just for your information. I just clicked it, and we are recording to the cloud. Justice Torres just gives me
the meeting. We're on.
Okay.
Start.
Good morning, councils, and thank you again for supporting our virtual courtroom oral arguments. This is how we are going to proceed for the foreseeable future. And at this time, I'm going to ask the clerk to call the case.
This is Supreme Court case number CVA19-014 in the name of Island Eye Center, Inc., doing business as Island Eye and Retina Center, Plaintiff Appellant, versus Peter N. Lombard, MD, Advanced Eye Care, LLC, doing business as Lombard Health, Desiree Nedadog, John and Jane Does 1 through 20, defendants, appellees. Island Eye Center, Inc., doing business as Island Eye and Retina Center, plaintiff appellant, is represented by attorney Daniel J. Berman. The defendants, appellees, Peter N. Lombard, MD, Advanced Eye Care, LLC, doing business as Lombard Health, Desiree Nedadog, John and Jane Does 1 through 20, are represented by attorney Delia Lujan Wolf. Mr. Berman reserves 5 minutes for rebuttal.
And so just again, counsels, to remind you, unlike our process if we were in the courtroom in person, we are going to allow each counsel 5 uninterrupted minutes at the beginning of their argument before any justice is allowed to ask any question. And we're just trying to proceed in a more organized way in using our virtual courtroom. At this time, Mr. Berman, you are recognized. Please begin.
Thank you, Chief Justice. May it please the court. Island Eye appeals from the grant of summary judgment that found no genuine issue exists as to any material facts, and that Island Eye has no trade secrets. Facts in the record, however, support the claims of misappropriation of trade secrets and breach of contract. Inferences in favor of Island Eye had to be drawn by the trial court in favor of only the non-movant on the summary judgment motion, but were not. Trial court assumptions of fact need to be vacated and from the decision granting summary judgment. The cases in particular of Thompson, 7 Cal Reporter 427, Moss Adams 224, Cal Reporter 456 explain that the review of a trade secret claim involves questions of fact that require a trial before a judge or jury. In the court below, however, assumptions of fact were erroneously made and no inferences were drawn in favor of Island Eye's detailed filed opposition declarations in response to the motion for summary judgment. First, the court erred in assuming and concluding Island Eye had no trade secrets. On summary judgment motion, defendants did not dispute that Island Eye had trade secrets. Instead, defendants limited their allegations to only that they did not see and did not use trade secrets. They did not assert that Island Eye had no trade secrets. Even though defendants failed to dispute the elements of trade secrets designated by Island Eye, the declarations of Dr. Smith and Dr. Flowers identified abundant facts and details of trade secrets with attachments of specimens. Dr. Flowers and Dr. Smith explained in detail their trade secrets' purpose, security, confidentiality, and medical internal protocols and procedures, all unknown to the public. Defendants produced no evidence on trade secrets. Notwithstanding this record, the court ruled that Island Eye had no trade secrets as a matter of fact. Surprisingly, the court made assumptions of fact. Quote, "It would be somewhat surprised to learn that LASIK and other medical procedures at Island Eye deviate appreciably from medical procedures at other clinics, page 17, decision order, and took extrajudicial notice with this assumption of important yet disputed fact that, quote, any eye clinic on Guam or elsewhere, such as the mainland United States, would use approximately the same surgical and nursing procedures, including LASIK procedures. Decision order, page 17. There is no evidence to support these findings of fact adverse to Island Eye. Island Eye's declarations explain its 20 years of specialized eye and retina care that included their exclusive development on Guam and application of LASIK technology, and their customized procedures developed by Dr. Flowers and Dr. Smith on Guam, only for Island Eye. The court below stated findings of pure assumption of fact that could only have been developed outside of the courtroom and outside of this record. Second, no inferences are drawn in favor of Island Eye's trade secrets from the detailed declarations and exhibits filed against defendant's motion. The court thus impliedly shifted the burden at pages 17 to 18 on the motion for SJ to Island Eye. Inexplicably, the record will show this court that not one hearing in open court was ever held on this motion for SJ or any other of several filed motions for Island Eye. This trial court record is void of any hearings, other than a scheduling conference maybe. In the jump to grant summary judgment, the court overlooked or disregarded Dr. Flowers and Dr. Smith's declarations and their supporting exhibits showing trade secrets, medical protocols, and procedures, and how these protocols and procedures are the definition of trade secrets. As a result, Island Eye not only had to defend the motion for summary judgment, but also defend against the Superior Court's surprising assumptions of fact that were only disclosed after the entry of decision order granting summary judgment. Let's review Dr. Flowers' declaration first. He developed and supervised the creation of LASIK checklists and protocols for Island Eye, specifically on Guam for Guam. He trained Eddie Dog to use, apply Island Eye checklists and protocols in about 150 separate procedures. Island Eye checklists and protocols were filed as Exhibit A, under seal to protect confidentiality in the record below. No Island Eye employees use or work from a mental checklist to provide mental care. Dr. Flowers observed Nettie Dog in her application and training on Island Eye's checklists and protocols. The protocols and checklists were written exclusively for Island Eye. Dr. Flowers personally trained Nettie Dog in her use of the protocols and checklists for specialized LASIK computers, equipment, and machinery. Importantly, none of Dr. Flowers' declaration and specimen trade secrets were disputed by the defendants. Attached to Dr. Flowers' declaration was Exhibit A, 4 parts of those trade secret protocols and procedures.
So Mr. Berman, even if we were to assume that the binder and the information contained in the binder could come in as trade secrets under a definition that this case will afford this court the opportunity to establish, since Guam has not adopted the Uniform Trade Secrets Act. Going to the issue of the misappropriation of trade secrets. So even if we were to assume the binder contains information that constitute trade secrets under a definition that we would probably adopt in this case. Going to the tort element, separate from the breach of contract, I want to discuss, because that's where I'm a little I have problems in reference to the case, and that has to do with the common law misappropriation of trade secrets. And as you've pointed out, that Guam has not adopted the Uniform Trade Secrets Act. And so if we were to look at California pre-1984 and their case law, they have adopted a test for this misappropriation claim, and I'm utilizing this. There may be other tests that can be looked at, but it's a 3-part test, and one of the main element has to do with the facts that allege must show that the third element of this California pre-1984 test, that the public policy in favor of protecting the complainant, in this case Island I, that the public policy outweighs the interests of the employee in using the knowledge to support himself and other employment. So even if we were to assume binder constitutes trade secrets, we were to adopt a test in terms of a common law misappropriation claim, separate from the statutory, any statutory violation under 88105. How is it that your client has satisfied that there's been a showing that the defendant in this case misused or in some way violated, uncovered these trade secrets in violation? Because your allegation is that the trade secrets came to defendant's attention because he unlawfully hired, not unlawfully, but did not hire the employees. That the hiring was done in violation of the let me see, it was the unsolicitation clause. So how is it that your client would overcome summary judgment in being able to show that the public policy of having the employees being able to readily use this information outweigh your client's interests?
Thank you, Chief Justice, for the question. I'm going to focus primarily on your part of the question that is going to public policy and the need of Island I to satisfy what would be the public policy satisfied by enforcing what are these covenants not to compete or covenant not to solicit, and enforcing a common law action, misappropriation of trade secrets. And that is predominantly, we focus on Guam. And in Guam, we have only 150,000 people situated 7,000 miles from the coast of California. And if we have a Guam business that is paying to import technically specialized, in this case, medical specialists in eye retina care from around the world, Israel, the States, Minnesota, Chicago, and pay for that relocation and placement on Guam to serve this small population, that investment should be protected by the public policy of the courts to see that Guam business employers are protected in some, at least minor way, by being allowed a key to the courthouse door to make a case. And in this case, we know that we have signed contracts. And to distinguish this particular case to what goes on in California today, we know in California, they have evolved codes that protect employers' trade secrets by giving that power of injunction by statute to employers in California. We don't have that in Guam at all. The legislation never developed. We have the counterpart California code from pre-1984, as you point out, Your Honor.
Yeah, but in California, prior to 1984, they also did not have the Uniform Trade Secrets Act, and they developed a body of law under the common law. And we have also the restatements, first and third, first in this case. And so we're in a similar circumstance, and the legislature has expressed a policy in favor against restraint of someone exercising their profession. But in this case, more importantly, the conflicting concern has to do with the mobility of employees to be able to seek employment that is in their better interest. And if it's such that it's in the better interest to seek employment to a competitor by prohibiting the employee from utilizing skills and information that may have been learned over a period of time from a prior employer would seem to run contrary to the public policy that is ingrained in 88105.
Thank you, Chief Justice. I take your point. And what we pointed out to this court in our briefs was the common law development of the trade secret exception to the enforcement of covenants not to compete. And again, we concede freely that the covenant not to compete is dimly viewed in all courts across the country. But when the trade secret exception is involved, and we believe the California courts historically had evolved the trade secret exception to allow enforcement. And in this particular case, we think these facts fit those older California cases that had the evolved exception under the trade secret definition to the covenant not to compete. And for those reasons, we point the court to those particular factors when California was a smaller state, and in particular, in our circumstance in Guam, where we have so few people and so few specialists, that the protection of this kind of employer should be extended in order to allow an open court report.
Mr. Berman, the policy of being a small location with a limited number of specialists, doesn't that undercut the enforcement of the covenant not to compete? And I just want to make sure, because on appeal, you really did not brief the issue of the covenant not to compete and whether or not Dr. Lombard directly competed with you when he established his own medical clinic or with Island Eye, or while under contract with Island Eye began working for another eye clinic. The focus, it seems, on appeal was looking at the California code and the California law protection of employer trade secrets and guarding against unfair competition, it seems, through the common law exception. So, I mean, are you still asserting on appeal that a non-compete clause as contained in the contract is a valid clause that can be enforced?
Thank you, Justice Torres. The Island Eye brief on appeal, I thought, was clear that we are advocating that the covenant not to compete in the exception for trade secret protection is enforceable. And in all these particular.
Yeah, so on trade secrets, but not for purposes of restraining Dr. Lombard from engaging in a profession as an eye doctor.
Thank you, Justice Torres. I take the point, and we do concede he should be allowed to have some business practice in the future. But I would note that in this particular covenant not to compete, there were limitations. A sunset time limit exists, a geographic limit existed, and there were a provision for him to go to private practice and compete when that time came.
But I mean, that was, the period was 66 months. And then I know the addendum reduced it to a period of 30 months. And so are you suggesting that a clause that is reasonable would be enforceable under the 18 GCA 88105?
Justice, and I would submit that a carefully tailored covenant with limitations on geography and time should be deemed adequate to at least go to trial, if not to judgment.
But the language of 88105 is pretty broad. It talks about every contract by which anyone is restrained from exercising a lawful trade or business or profession of any kind. And the only two exceptions are for sale of goodwill and a partnership agreement. So are you suggesting that we interpret the plain language of the statute in a manner that permits restrictions geographically and time and duration?
Thank you, Justice Torres. I think as a first response that I would hope that the court doesn't have to reach every element that can be unpacked from these briefs, because this decision order covered at least 25 law reviews and 55 subjects. But what I'm looking for here on this record is the reversal of the grant of summary judgment, declaring that no trade secrets exist whatsoever, and an opportunity in the trial court to go forward. And to rewrite the actual covenant not to compete actually was part of the brief that we filed. That is by
and Mr. Berman, that's
solicitation.
and that's the very reason why I focus in on the misappropriation claim under common law and the potential tort action. I think the breach of contract claim and the existence of the statute, there's an uphill battle in reference to the position you're taking for us not to follow the straight statutory interpretation and look at the development of the law in California and what remedies exist. And so again, my focus is on the misappropriation of trade secrets claim as a tort action and the development of that under common law, in particular California's pre-1984 case. And even if we were to assume that the materials in the binder constituted a trade secret, and you still must overcome the summary judgment elements in reference to making a claim for a misappropriation of trade secrets under a tort issue. And I just don't see any allegation, because you seem to just focus on the what is the definition of a trade secret, number one, and what constitutes is a question of fact. And even if I was to grant you that, you still need to come forward with some arguments and some proof that the policy, because your assertion of where this tort arises is that Mr. Lombard solicited these employees, and these employees have all this knowledge in their brains, in their minds, because there's been no showing and no allegation that Mr. Lombard took a picture of the binders, made copies of the binders, and in that way violated that element, that he was able to obtain this information to support the tort claim by hiring these employees, and these employees will inevitably have this information and use it, provide it to Mr. Lombard. And I'm merely pointing out that the third element of this California misappropriation pre-1984 claim requires a balancing of the policies. And in this case, there's an express provision in terms of the policy, well, not express, but a strong policy in favor of employees. And so that employees should be able to use whatever skills and knowledge they obtain during the course of their employment career. And so I think that's where your client may have some challenges in trying to overcome summary judgment, even if we grant you that these trade secrets, at least the binder is constitute trade secrets, the elements of the misappropriation under common law as to this claim, I don't see it in your brief or in your moving papers in reference to this part of the argument.
Thank you, Chief Justice. If I may respond. The point of this appeal is that Island Eyes, the plaintiff, responded to this defendant's motion for summary judgment. And what the court's pointing out now in the question, I don't believe was a constituent element of the motion for summary judgment. What the motion said to us was that we didn't see and we didn't use their trade secrets and protocols. That we rebutted, that we had evidence for, that we had declarations and deposition excerpts for, and that is what we fought. Now, when the judge ruled and granted summary judgment, we were, lo and behold, surprised by a complete briefing on the law of trade secrets and the covenants not to compete and applications that weren't part of the motion. It is that aspect of this case that is not really acceptable, and that's why we're on appeal. If we go back to the trial court, we will address those additional legal features that will present obstacles to us before the trial. And we'll
Yeah,
bring
but Mr. Berman, under standard of review on an appeal, it's a de novo standard of review. And you have asserted a misappropriation claim under common law that your client should be able to recover in the event that 88105 invalidates the contract. So even if you were to set aside the contract in terms of the unfair trade practices, you still potentially survive summary judgment if there is a misappropriation under common law as a tort claim. And so that's the reason why I'm focusing in on this element of the to just see if that, even if your client was not to prevail on the contract remedy, whether or not there are genuine issues of fact in reference to the misappropriation claim under the common law tort theory.
Chief Justice.
Go ahead, Mr. Berman.
I was just going to point the court to the record in support below that showed the court that there were multiple facts in support of the Island I position on misappropriation of trade claim. Take just a couple, that these defendants contacted 10 of their employees and hired 5 of them, and that they started their business while Dr. Lombard was a contract employee of Island I. Just put those two together there. The emphasis to be drawn is that this is a raid and a poaching unlimited. This is a direct assault on a business model and the taking of the complete model over by the 5 employees. And the way that they did that, described in the deposition excerpts, is by calling and writing and asking, oh, will you accept a little bit more money? Oh, you don't get paid that much there. Oh, the top manager's ready to be hired. There's no room for you to go up. It's all predatory on the existing work that they were in or had to go after Island I and misappropriate their business. Thank you, Justice Torres.
I think that focuses on the non-solicitation issue, but getting back to the misappropriation of the trade secret, the trial court judge went through the prima facie claim for trade secret misappropriation. And he said you had to have a trade secret, that the Dr. Lombard somehow acquired, disclosed, or used it through improper means, and that the defendant's actions damaged Island I. And of course, the judge recognized that it's your burden, Island I's burden, to show that the procedures that you argued, the customized procedures, the office policies, the business model, the payroll, medical procedures, the client lists were all trade secrets. But then the court went through and in fact seemed to, suggest that you did not describe with particularity why those items reached the level of trade secrets. But even if it constituted confidential information, you did not show how they had misused that information, and that and he felt that you had to at least show how they exploited the knowledge, for example, about the insurance and the contracts with the doctors. And he seemed to think that that was missing from the establishment of the prima facie case. Similarly, with regards to the pricing, he recognized that not all pricing automatically constitutes a trade secret, but that even if you demonstrated that it qualified as a trade secret, you didn't show how it was used or how Island I was damaged by its use. So that seems to be the basis of what the trial court was relying upon. And taking that and the what was pointed out by the Chief Justice, I mean, the Chief Justice was, I think, trying to suggest that you're arguing that there's that we should look at the doctrine of inevitable disclosure, that an employer should be able to prevent a former employee from taking a position with a competitor by demonstrating that he's going to somehow rely upon what he learned at the prior job, and there will be disclosure to the competitor, and therefore that would constitute a trade secret misappropriation. Is that, I mean, how do you address the trial court's determination that you failed to establish your prima facie case? And then also, is establishment of the case contingent on our adoption of the inevitable disclosure standard?
Thank you, Justice Doris. If I could respond to the first part of your question on the burden shifting to Island I and the elements that it had to show in its declarations in opposition and its supporting facts. The court's question is put to Island I in the general, but what happened here is in the specific. You have to look at the motion for summary judgment that was filed. That's what we respond to. That I would know in the future what the trial court's concerns were and 4 or 5 other elements to a cause of action would be surprised. It was unknown. What was known is the motion before us. That's what we responded to, and that's why we are on appeal. Yes, there are more elements to these 4 other claims that we filed with our complaint, and the 3 or 4 elements per claim. You multiply that 3 times 4, you have almost 18 elements. So now to pick one of the elements out of 16 that wasn't satisfied below, there's explanation for that. That is because the motion for summary judgment didn't raise it. Had it raised it, we would specifically have come after that specific attack with our response to that attack. And in doing so, we would have asked the court, as we did, draw all inferences in favor of the non-movement. Don't make assumptions of fact outside of the record. Don't tell us you know what it's like in the mainland USA for all LASIKs. Don't tell us it's the same for all nursing procedures across the country. That's wrong at so many levels. And for that reason, we want to go back to the trial court and show that court what we have. And we weren't able to do that on this record when summary judgment was granted. Thank you, Your Honor.
Are there any other points that you want to make in reference to your case in chief?
Thank you, Your Honor. I'm showing on my watch clock about 30 minutes now. I think I ran out of time.
Okay, all right. I was not even looking at the clock. All right, Mr. Berman. I'm going to ask Justice Merriman if she has any questions for you, and we'll allow that additional time.
I'd just like to sort of go back to the fundamental question of what definition of trade secret do you think the court should follow? There's the California definition, there's the restatement definition, some other cases that were cited. Just the very basic, what factors go into establishing the existence of a trade secret?
Thank you, Justice Merriman. I recall reading opening brief, page 18, our submission of a trade secret definition of 3 elements. A, there is information. B, which is valuable because unknown to others. And C, which the owner has attempted to keep secret. That is ABBA Rubber, 1991, California. So we're more than satisfied with that definition, and we believe we met it in spades and showed the court all 3 elements on the trade secret. And if that were the adopted definition, certainly Alan and I would be satisfied. Thank you.
So you don't think
I was just going to say that, Justice Merriman, that's pre-California. California's pre-uniform definition.
So, Mr. Berman, you don't think there needs to be any other additional considerations about how much money was expended in developing the information, the difficulty with which the information could be acquired or otherwise duplicated?
Thank you, Justice Merriman. The response would be that those particular elements would be satisfied if a adverse motion was filed to bring it up, and we would meet it. And in trial, we would have to show it. And I believe we have documented a great deal expenses invested in these trade secrets. my 20 years of practice in hiring off-island doctors, their plane fares, their moving expenses, and their signed written agreements to non-disclosure and confidentiality of trade secrets. But the money spent, I believe, would be an element of our damages, and we would show that at a trial.
Because these are factors from the restatement. So they're factors considered by the restatement. That's why I was asking. So you really want to stay with the California definition and not look to other definitions?
Justice Barrett, I think all courts below can look beyond California, and we've pointed out to reasons to go beyond California. And certainly we would look to more favorable pro-plaintiff jurisdictions, but California being a little bit more pro-employee than employer, we offered California as really the employee-oriented definition and not really an employer definition.
Okay, thank you.
Thank you, Justice.
All right, thank you, Mr. Berman. And so your time is up. At this time, I will recognize Ms.
Real quickly, Chief Justice, can I just ask one question on the definition? Yeah. The trial court looked to the Guam code for definition of a trade secret, and that was 9 GCA 43.10. Do you think its reference to that provision was relevant, Mr. Berman?
Your Honor, I'd have to reflect on their decision order again. I thought the briefs addressed it, and I would rely on the brief that I filed.
All right.
Yeah,
okay,
that was Guam's criminal statute definition that Justice Torres had referred to of trade secret. All right. At this time, Ms. Wolf, you are recognized.
May it please the court. The trial court properly granted dismissal and summary judgment on Island Eye's claims and in favor of the defendant's appellees. In this appeal, Island Eye only focuses on the dismissal and grant of summary judgment as to 3 causes of action. And those are a breach of contract claim regarding the non-compete provision, breach of contract claim regarding the non-solicit provision, and the common law misappropriation of trade secrets claim. And in this case, it's notable that as your honors pointed out, that much of the appeal brought by Island Eye does not actually look at legal arguments. It's not actually looking at whether or not the non-compete and the non-solicitation provisions violate Guam law 18 GCA section 88-105. It's not looking to whether or not the appeal doesn't make an argument that the court was incorrect in finding that trade secrets were actually used by the defendants in any way that was disadvantageous to Island Eye, or that they were used at all. And regarding the non-solicitation and non-compete provisions, Guam law section 88-105 clearly evinces a strong public policy in favor of open competition and employee mobility. It requires that any contract that is restricting of a person's ability to practice a profession, a trade, or any business is void under Guam law. And so in this case, we have 2 provisions of the contract which clearly do that. The non-compete clearly restricts Dr. Lombard's ability to engage in any practice of ophthalmology, optometry, during a period of 1 year after separation from employment. The non-solicitation provision clearly restricts the ability to hire employees, even if they're from Island Eye. And it is not limited in time or geography. So it is to exist in perpetuity, the non-solicitation provision. And so Island Eye does not actually argue that these are valid provisions, but only that that Guam, or that the court improperly applied 18 GCA section 88-105 because Guam lacks a statutory cause of action for misappropriation of trade secrets. And as Your Honors pointed out, this is a flawed argument because Guam does recognize common law claim for misappropriation of trade secrets. Island Eye admits that it's the very first cause of action that it has brought in its complaint. And the trial court did not ignore that common law claim. The trial court did not dismiss or grant summary judgment outright, saying that there is no such common law claim in Guam. The trial court considered the elements and found that that Island Eye failed to meet its burden to show that there were trade secrets and that they were used by the defendant's appellees. Now, I wanted to point out regarding the non-solicitation provision, even if this provision were to be enforceable, even if a non-solicitation provision were to be enforceable, again, this provision, this exact provision in Dr. Lombard's employment contract is not limited in any way. It disallows him from soliciting directly any Island Eye employees. And that under the case law, under other case law, it would be an invalid provision because it's not narrowly tailored in any way. It's also not narrowly tailored to focus on protection of trade secrets. There's no mention of trade secrets in the non-solicitation provision. Also, although this authority is not cited in any of the documents, any of the filings, I wanted to point out a recent California appellate court decision, which is AMN Healthcare Inc. versus Aya Healthcare Services Inc. And that is found at 293 Cal Reporter 3rd, 577. It was a decision.
Ms. Wolf, if you did not cite that case in the briefs and counsel didn't have the opportunity to respond, there is a process for you to submit post arguments in terms of letter form that authorizes counsel to, affords counsel the opportunity to respond. So I would suggest you follow that process. But in reference to the non-solicitation clause, if 88105 doesn't automatically invalidate that provision, if we were to follow California law in reference to the non-solicitation and there's some exception in terms of reasonableness. Mr. I think Berman pointed out in his briefs that this provision it really only applies to Dr. Lombard. It restricts Dr. Lombard. It doesn't restrict the employees from contacting Dr. Lombard and in reference to seeking employment. And so when you're trying to balance, assuming we follow California law and find some exception in reference to 88105 as it applies to the non-solicitation clause, and look at the reasonableness. A part of the argument also is that the employees were not restricted from seeking other employment and using their knowledge that was gleaned over the years that they worked for Island Eye. So couldn't it be said that it was narrowly tailored because it was only it only restricts Dr. Lombard from soliciting and not the employees from inquiring as to the availability of work with Dr. Lombard?
Thank you for the question, Chief Justice. The provision is not narrowly tailored because it is not limited in time. It it's to be effective forever. It's not, although it does only restrict Dr. Lombard's ability to initiate contact with Island Eye employees regarding employment at Lombard Health, that provision is still a restraint on his ability to find employees and to operate a competing clinic in Guam. And so, although it is correct that only Dr. Lombard is restricted from initiating contact and that he can consider inquiries for regarding employment, it still violates the strong public policy that was set forth by the legislature in enacting Section 88-105. It is an agreement that restricts his ability to engage in a profession. And even if that non-solicitation provision were to be construed as lawful under Section 88-105, the facts here don't support that there was any solicitation by Dr. Lombard. In fact, in this appeal, the record shows, and it's not disputed by Island Eye in this appeal, that any Island Eye employee was the first, any Island Eye employee that later went to work over at Lombard Health, or any Island Eye employee at all, was the first to initiate contact with Dr. Lombard or anyone at Lombard Health. It was not Dr. Lombard who was the first to contact Island Eye employees to ask if they wanted to work at his clinic.
Isn't that a question of fact? Wasn't that disputed by Island Eye in references to who made initial contacts? Isn't that a question of fact that cannot be resolved in summary judgment?
It would be a question of fact, but these are undisputed. No matter how Island Eye wants to frame a question or a dispute, the facts, the record is there, and it's undisputed that Sally Menor contacted Desiree Netadog to ask about employment, and that's or that Myra Regis or Nicole Agage. These are prior Island Eye employees who were specifically identified by Island Eye as being solicited. Each one of those specifically identified employees was the first to contact Dr. Lombard or anyone at Lombard Health, if it wasn't Dr. Lombard, to ask about employment. And so there is no evidence that Island Eye has put forth to show that any inquiries about employment at Lombard Health originated first with Dr. Lombard. Dr. Lombard did not initiate that discussion. And so the facts simply don't support any solicitation, any initial contacts by Dr. Lombard of Island Eye employees. And
let me discuss the grant of summary judgment on the common law misappropriation of trade secrets. Mr. Berman points out that the manner in which the summary judgment motion was filed and framed, that they came back and rebutted, at least by creating issues of fact as to whether there existed trade secrets by showing Dr. Flowers' testimony and stating that why this was important and this was an evidence of a trade secret. And similarly, they went forth and said there was at least enough put forth to create issues of fact. And they were surprised that the trial court went beyond just addressing these, whether there existed issues of fact on the existence of a trade secret, but went through the entire analysis of whether there was a merit to the common law misappropriation of trade secrets claim. And they felt that they were caught blindsided by the decision of the judge because they did not address the remaining aspects of their claim and were focused only on establishing a genuine issues of material fact for trial.
In response, Justice Torres, the trial court looked at the elements, not just whether or not a trade secret was specifically identified, but also whether or not trade secrets were actually misappropriated or used by the defendants. And so as to that particular element of whether or not there were trade secrets, the trial court correctly found that Island Eye simply failed to carry its burden of proving, of specifically showing what information or property was a trade secret. Island Eye simply, except for, there are two exceptions where there was more specificity, and that would be the LASIK checklists and protocols. There was also some specificity as to salary information, although the complaint fails to actually make a claim for misappropriation of salary information as trade secrets. So there is actually no complaint, no claim raised as to salary information. But setting aside those two specific items, Island Eye simply engaged in, as the trial court said, general hand waving. Island Eye only listed categories of items such as protocols, business model, checklists, certain checklists. Island Eye failed to specifically identify what nursing protocols, what exactly about the model is unique or so different from everyone else. And so, except as to the LASIK and salary information where there's more specificity, everything else was just identified as general categories of information or property. And Island Eye completely failed to be specific in what the information was. And so, lacking that specificity, the court was unable to determine whether or not this, or what this information is that's being alleged to be trade secret, and whether it actually qualifies as a trade secret. This is a burden that the plaintiff owes not just to the defendant in allowing the defendant to understand what is being alleged as a trade secret, but this is a duty that a burden that must be met for the court's benefit, because the court needs.
But I think Mr. Berman's point of contention is that it felt that it had to prove why certain information was a trade secret. And the trial court, in rendering its decision on summary judgment, made the case that, well, even if you were going to demonstrate that some of the information you had qualified as a trade secret, you failed to show how they acquired it or used it, and or how you were damaged by it. And I think his point of contention is, if we had known that that was what the trial court was interested in when we responded to the motion of summary judgment, we would have brought up information showing how Dr. Lombard acquired this information and how Island Eye was damaged by this information. But I get that his contention is that when the summary judgment motion came in, it was focused on whether or not the information even constituted a trade secret. And so if the information could not qualify as a trade secret, if they couldn't prove that they had a trade secret or owned a trade secret, then obviously they couldn't even meet the first test for what would be a prima facie claim for trade secret misappropriation. So I think his argument seems to be, well, I came in, I established at least the first element of the trade secret misappropriation claim, and so there's no factual issues in that regard, or at least if there is, there's factual issues that would go towards trial. But the judge went beyond that and looked at the other issues, other claims that are necessary to establish the prima facie case.
The trial court acted sua sponte at most in looking at whether or not information was a trade secret as alleged by Island Eye. And I say at most because I'm not agreeing that that's what happened, but the case law that we've cited in our response clearly shows that the court would have been allowed to do so. In Agency Solutions, a case out of California, the court held that a trial court can reject a claim that information is a trade secret sua sponte if the information is not identified by the claimant with sufficient particularity to allow the court to determine what the information is. This is a threshold issue. If a plaintiff is claiming that something it was misappropriated as a trade secret, it's the burden of the plaintiff to identify that. And it's incorrect. It is incorrect that the issue of whether something was specifically identified enough as a trade secret can only be reserved as for trial. It's incorrect that that can only be decided on trial. In my response, I did cite a case that in which a California court affirmed a dismissal of a complaint of a trade secret claim for the plaintiff's failure to specifically identify the trade secret. And so it is appropriate to resolve the issue of whether or not the plaintiff has specifically identified the information that it claims to be a trade secret. That is an issue that can be resolved in a summary judgment motion or even on in a dismissal motion. And
let me ask this, Ms. Lohan. If Guam was, if our court was to adopt the doctrine of inevitable disclosure, and that we assume that Island Eye has produced evidence that its trade secrets qualify for legal protection, and that is that it constitutes, trade secrets. And on the misappropriation claim, and if we were to adopt the doctrine of inevitable disclosure, then would Island Eye misappropriation claim survive summary judgment in that the misappropriation was the solicitation of these employees contrary to the provision in the contract of non-solicitation, and that now having these employees who have all this information that was learned and over the course of their employment with Island Eye, would Island Eye then be able to survive summary judgment on the misappropriation claim? At least, that's the allegation.
thank you for the question. If the doctrine of inevitable disclosure were to be recognized in Guam, then which we dispute that it should be because it violates section 88105. But if that doctrine were to be held to apply here to Guam, Island Eye would still be obligated to show that an Island Eye employee's later employment at Lombard Health would inevitably lead that employee to use Island Eye's trade secrets. And there's a total absence of any evidence in the record to show that that any trade secrets learned over Island Eye would have eventually been used over at Lombard Health. There's simply reliance on the doctrine, but even failing to prove that that Island Eye succeeds under the doctrine. And so this is basically the entire argument of Island Eye as to how the defendants used or misappropriated Island Eye's trade secrets. It's simply the assumption that these employees of Island Eye had this this trade secret information in their heads, which they of course would have had to use later on at Lombard Health, another competing ophthalmology clinic. And if Guam were to adopt that doctrine, then that would make it almost impossible. It would make it dangerous for an employee who works in a particular business to later work at a competing business, because then they would be open to being sued for trade secret misappropriation. It would make it impossible for someone who learned skills, who was trained at Island Eye, to later work at any other ophthalmology clinic in Guam. And the trial court recognized that this doctrine is wholly incompatible with Section 88-105, which requires that there be open competition and employee mobility. That adoption of that doctrine of inevitable disclosure here in Guam would severely limit an employee's ability to move to a competitor.
Could it be narrowed in reference to, it depends, you know, even if we were to adopt the doctrine and you were to distinguish between, say, Ms. Nedaduk, who was a supervisor, had a position of management supervision, as opposed to the techs, the other employees, and as we saw in the PepsiCo case, you know, it was an executive who was in a position to share the knowledge in reference to the competition with the type of sports drinks that they were talking in it, because of the nature of the position. In this particular case, even if we were to adopt the doctrine of inevitable disclosure, would it necessarily apply to the techs, say, as opposed to some executive level employee?
I don't believe that it would apply, or that Island Eye has succeeded on the record in showing that that doctrine that it would succeed using this doctrine in this case. There is no evidence that any information that employees learned at Island Eye was so secretive, that so much money was spent in developing this information or property that this information would then later on have to be used, or you know, at a competing business. There's no showing of that specific trade secrets would have been used at Lombard Health. As a matter of fact, Island Eye itself has admitted through its two representatives, being the general manager, Melissa Newcomb, and its chief executive officer and owner, Dr. Anthony Smith, that it doesn't actually know what supposed trade secrets were used at Lombard Health. Dr. Smith himself testified at a deposition that he has no idea what Lombard Health procedures, protocols were developed using any Island Eye property. And so again, he admitted that the only information that he has is that these were employees of Island Eye who learned, who were trained, and then went later on to work at Lombard Health. And he assumes that that they would have used information in a 3-ring binder. And so this is very weak circumstantial evidence even to support the doctrine. And so having admitted that it has no idea what exact information was in some of these employees' heads and was later used at Lombard Health, Island Eye admits that it cannot, and has failed to show that it cannot, or that there is no evidence that Lombard Health, Dr. Lombard, or Ms. Nedadog actually used or misappropriated Island Eye property or trade secrets. Island Eye only relies upon, regarding use and misappropriation, it only relies upon this doctrine of inevitable disclosure, which it even fails to prove that it would succeed under. And so, in this case,
Let me ask a question about the covenant not to compete and really 18 GCA 88105 and the breadth of that section. If there was some controversy regarding whether or not Dr. Lombard had worked at the competing clinic in violation of the non-compete clause, because even though under the addendum, they allowed 2 weeks of clinic coverage at St. Lucy's Vision, there was a question of whether or not he had potentially exceeded that time frame or had done it during the period of time when he was still under contract. But when you look at the general language of 88105, it seems to prohibit any restraint on practicing a profession from exercising a lawful profession. And my question is, so does that mean that someone can have a contract with an employee and provide that the employee cannot hold another job during the time that they're contracted with the employee? So he can't engage in any outside employment or any outside activity that conflicts with the employee's duties while employed at with the employer. Would that type of contract be in violation of 18 GCA 88105?
but it's correct that that section 88105 is very broad in scope. And although we do have that strong public policy of employee mobility and open competition, there is still the a common law cause of action for breach of fiduciary duties, which Island Eye did raise and did fail on under summary judgment, and has not appealed the grant of summary judgment as to the breach of fiduciary duties. But basically, the fiduciary duties goes to the duty owed by employees to not harm their employers. And so,
well, let's say that there was not a breach of any fiduciary duty in the performance of that additional employment, and so, but it's still a provision in a contract that restrains the employee from holding employment. Should we not want to encourage an employer to be able to control the ability of an employee to engage in employment during the time that they're employed with an employer? Or do we say, well, the 18 GCA 88105 language is so broad that it is a restraint on trade and there's nothing the employer can do? That also seems problematic in my view.
that is a very good question, and it's a difficult one to answer, because as I sit here, I mean, I can't cite, but I believe that there is some Guam law that restricts government of Guam employees from outside employment. I mean, I believe that may be the case, and so, however, I don't believe it is unreasonable, although reasonableness should not be, there's no reasonableness test that I'm advocating, but I don't think that, I think that it could be harmful to an employer if their employee is at the very same time working for a competing business, because there are duties that an employee owes to the employer, and that is to not harm the employer. And so if this is a restraint on the employee from engaging in a non-competing business, I do believe that that would be in violation of Section 88105. But because employees do have to not harm their employer and their employment, that they have to be loyal in the service of the employer, that it would be problematic to allow, or that it wouldn't be problematic to prevent an employee from working concurrently at a competing business. But it would.
So you think if it's a competing business or one that conflicts with the employee's duties owed to that current employer, that would be prohibited, but something that doesn't conflict or is not would be permitted.
Yes, and that is common for many people to have more than one job at a time. And it would restrict a person's ability to earn income if an employer could safely restrict employees from engaging in other employment. And we can't have that.
Attorney Wolf, I think your time is up, and just like we extended additional time for Attorney
She has
Berman.
3 minutes, or did she exceed it?
No, the time has been going back up again. Okay. So Justice Merriman, in closing, do you have anything because we allowed Attorney Berman the additional time? Do you have any questions for Attorney Wolf?
Yes, I'm going to ask you the same question. What do you think is the appropriate definition of trade secret in terms of the various factors the court should consider based on the different definitions that appear to be common in the U.S.?
I believe that appropriate test for this common law this common law claim would be looking to California case law. I think it would be appropriate to do that because Guam's statute regarding open competition and employee mobility is borrowed from California. And so to me, it makes sense to be for California case law to be persuasive on in the development of the standard or the test. And most, if not all, of the case law that was cited in the response brief is from California, and it does look to, or it does require the establishment of, stating that stating specifically with sufficient particularity that something is a trade secret, that this trade secret is owned by the plaintiff, and that it was kept secret, that the plaintiff, the owner of the trade secret, spent time and resources in developing this trade secret, so that the use by someone else would be to the advantage of that person who doesn't have to go through the expense and time to develop that trade secret. But it would also require, of course, that the plaintiff show that the trade secret was used, that it was actually misappropriated by the defendant, and beyond that, there was damages, that there was injury suffered by the plaintiff in the use of that trade secret. And in this case, under all the tests, Island Eye has failed to show that with specificity that certain items were trade secrets and that they were actually used or by the defendants, and that Island Eye suffered harm. Thank you.
So I'm sorry, Justice Merriman, do you have any follow-up?
No, that was fine, thank you.
Just Stars, I felt that Attorney Wolf answered your question, but if you don't feel that she did,
I'm fine.
Right.
I'm fine, just.
Okay, thank you, counsels. all your time have been used up. And so at this time, we will take the case under advisement. We thank you for your
Mr.
cooperation.
Mr. Berman has his hand up.
Yeah, Mr. Berman, go ahead.
Excuse
I
me,
know,
Chief.
yeah. You said you reserved time, but I thought you used up your time. And if the clerk is to tell me otherwise, I will allow you the, I thought you went and you used your entire 30 minutes.
Thank you, Chief Justice. I think there, if I may submit some ambiguity. You know, I say I reserved 5 minutes, and then at my 5-minute mark into my argument, the questions began and I answered all the
All right.
questions.
Okay,
I don't really know.
Yeah.
I don't know what the answer is.
No, but the response to that is that if you continue and we use up that period of time, then you've exhausted your time. But I'm going, because of how complicated this case is and important to our jurisdiction, a case of first impression, I'm going to go ahead and allow you to wrap up, clarify some points, and I'll give you the additional 3 minutes.
Thank you, Chief Justice. May it please the court. In response to Ms. Wolf's arguments, first on her point that there were no facts of solicitation by Defendant Lombard, I direct the court to opening brief pages 10, 11, 12, and quoting from the record and the brief. Dr. Lombard emphatically expressed his need to transplant highly experienced employees who could import a business model and run his office for him. He said in deposition, page 144, quote, "I will need people and experience, exclamation point, to Netty Dog." Again, in their negotiations for Miss Netty Dog's employment, Dr. Lombard directed her to provide him the names of, quote, "anyone who would be a good fit," close quote. Depo Lombard, page 145. Further, Dr. Lombard stated, quote, Ms. Netty Dog stated in her deposition, in explaining to Dr. Lombard, quote, "I'm not sure if you want me to ask here on this email or chat room, or if you have time to meet. I have a few people in mind that have got ophthalmology experience. How should I go about it?" Referring to approaching them. That's Depo Lombard, page 146. Put another way, Dr. Lombard stated his need for experienced people, and particularly fully trained medical technical staff, in his plea for post-haste transplant of a smooth running office. So it occurred, and it was in the record. And at page 12 of my brief, I noted that Dr. Lombard replied to Netty Dog, quote, "I'd like to hear who you have in mind first for potential employees." And then in talking to Arlene McAreg, another Island Eye employee, Lombard explained, quote, "He felt her skill set is what he needed right now, and he did not have a surgical suite ready to go yet." So that's in response to the argument of Ms. Wolf. Additionally, Ms. Wolf was saying there was no breach of duty of loyalty and covenant of good faith in the appeal of this case, but I refer the court to opening brief, page 6 and 7, where the factual argument of breach of those duties is set out. In closing, Island Eye's detailed medical protocols were unique and exclusively created only for Island Eye as trade secrets. The declarations of Dr. Smith and Dr. Flowers explain it. The inferences should be drawn only in favor of the non-move-ons, but here the inferences were drawn against Island Eye. Additionally, assumptions of facts cannot be made in the decision granting a summary judgment. As in 8 previous Supreme Court decisions set out in the reply brief of Island Eye, this summary judgment should be reversed for the use of disputed questionable facts. It is true, Island Eye was in fact blindsided by the decision and order. We didn't know this attack was coming because the defendant's motion for summary judgment never challenged the designation of trade secrets. The record of defendant's purpose and actions were to import a business model and technical medical operation by taking the most tempting shortcut at the least possible expense to accelerate their startup of a new expensive, equipment-heavy, specialty medical clinic offering surgery on the eyes. They did so wrongfully appropriating the one well-known business model they both had used at Island Eye and brought over those trade secrets developed there, and to do so solicited 10 of the Island Eye employees and hired 5 of the most technically qualified Island Eye employees who very well knew and were trained in those trade secrets and business model. In summary, Your Honor, we ask the case to be remanded, consistent with the opinion. Thank you, Your Honor.
Thank you, Mr. Berman. Thank you, counsels. The court will take the case under advisement. And again, on behalf of my colleagues, Justice Torres and Justice Merriman, we thank you for agreeing to have our virtual oral arguments, and we look forward to continuing these type of arguments. At this time, the court will stand adjourned. And I will switch off the recording.
Your Honor.
Thank you, everyone.